Welcome to the first episode of our new podcast entitled Decoding Gaming Law. My name is Franklin, lead consultant at CSB Group. And today our first guest is my friend Michael Cuschieri, who's the head of legal at LeoVegas. Mike and I go way back, I think almost 2 decades now, Mike.
Probably.
Unfortunately,
2 decades too long.
2 decades too long. But thank you for accepting our invite. Real happy for you to be here. So today we'll be touching upon our first topic, a general overview of the gaming legal framework. So I'm going to dive right in. So introduce a bit yourself.
Okay.
What you do on a daily basis, what do you oversee, and we'll take it from there.
Okay, so first of all, thank you for the intro and thank you for inviting me to the first episode of your podcast. I'm very happy to be here. As you said, I'm heading the legal team at LeoVegas at the moment. I've been there for quite some time, going on to 8 years now. Obviously, the legal department handles all legal matters for the business. We're involved in all the projects which the business undertakes, and obviously handling the legal aspects related to those projects. LeoVegas has quite a big legal department, so we have separate compliance teams, separate privacy teams, but obviously as a legal team, we work very closely with all these other departments within the company. Yeah, so that's me. And
I believe as well it's something that you wouldn't just focus on Malta as a jurisdiction, being LeoVegas a multinational enterprise. I'm sure you have other jurisdictions, and how does that work? Do you have partners abroad?
So yes, you're correct. LeoVegas operates in a number of jurisdictions in Europe and outside of Europe. Obviously, we have an extensive network of lawyers, external lawyers who we work with in relation to the legal aspects pertaining to each jurisdiction. Mm-hmm. We also have a multinational legal team. So, for instance, we also have now within the group a Brazilian lawyer who would work on Brazilian law aspects. Mm-hmm. So yes, obviously we do have a number of lawyers from several jurisdictions working with us.
So what's interesting as well is that you get to see the various laws of various jurisdictions. So you get to see not I think Malta as a gaming law jurisdiction was one of the first to legislate, correct me if I'm wrong. Do you see a lot of discrepancies, and do you see Malta, so question number 1, do you see a lot of discrepancies between the Maltese gaming law and other jurisdictions? And question number 2, sort of, is Malta leading the way when it comes to gaming law, especially in Europe, or Malta still has a lot to learn in that respect?
So the fundamental principles of the different laws are relatively similar. So all laws usually have as priorities ensuring the protection of the player, combating money laundering and financial crime and so on. But yes, there are several differences in the detail. So the nuances of the legislation of all different territories are very, very different. And that is quite a challenge to operators. In terms of whether Malta is leading the way, Malta is obviously a mature legal framework. It's been around for a while, and now we are seeing many new legal frameworks cropping up around different territories as countries regulate. So in that sense, I would say Malta is still at the forefront. But I think where the strength lies is that in Malta we have a whole now ecosystem. So it's not just a mature legal framework. We have companies which are established here. We have local talent. We have service providers on every aspect. We have legal service providers, corporate service providers, financial, and so on. So I think in that sense, Malta is at the forefront. Yes.
Okay. And when you see the biggest challenges when you look at different jurisdictions with different laws, you can have conflicting laws as well. What do you see in your, maybe not day to day, but whenever you have a conflict of laws between jurisdiction and the other, how would you approach that?
Okay, so I don't think we deal with issues of conflicts of laws too frequently. Why? Because we know that if we are talking about our offering in a particular jurisdiction, then it is the laws of that jurisdiction that we have to look at, and there's no question of other laws which are conflicting.
Okay.
Where the challenge lies is the fact that there are so many different nuances between the different laws. So that is also a challenge from a tech perspective as well. So you have the laws which are impacting operators from a tech point of view. So to give you an example, if for example one of the jurisdictions has certain requirements about geolocation requirements, right? The tech, the devs will develop something to meet the requirements of that particular legislation.
Yes.
If a different territory implements geolocation requirements in a different way, then what happens? The tech team have to go back to what they developed and adjust that again, or create a system which works in parallel to meet the requirements of that jurisdiction.
Yes.
And as you have more and more territories regulating, these things become more and more complex.
Exactly.
So I think that is a particular challenge that operators are facing.
I think we really delved right into it, like not even like a short, which is good, and I like that.
Good.
But I'm going to take it a step back.
Okay.
So you've been in the industry a bit for quite some time. You said over 8 years. When you look at how, back in, I think it was 2018, where there was an overhaul of the gaming legislation. If you look back, if you stop and think back of how the law was, 8 years ago and when it is now, do you see it as we improved, or do you see it as becoming too bureaucratic and too detailed, where it's stalling operators?
No, I think the law improved. I think it's very important actually that the law continues to develop. Why? Because the gaming industry, which is essentially a tech industry, is fast changing and
very fast
developing,
changing, yes,
as any other tech industry.
Yes.
So if laws do not adapt, and if laws do not, if we don't get more detailed laws, if we don't get more guidance from regulators, then the laws that you have quickly fall out of applicability, and they no longer remain appropriate for the reality in which the business will be operating. So yes, I think legislation and continued development of the legal framework and making it more and more robust is the right direction.
And I think, as you mentioned in the tech, we always have that problem where the technology advances at such a rapid state. And for example, AI, it's very in vogue at the moment. Everyone's mentioning it. The AI Act, the European AI Act, was actually developed after. So the law is always catching up with technology. And I'm sure that creates a problem, because especially with the developers, because they developed something and then the law comes into place and they have to dismantle again that technology. I don't know if you agree or you have any other.
Absolutely. No, I think that is a problem which is endemic to technological development. It happens so fast. The next big thing comes along and it takes everyone by surprise. Case in point, we have AI, which
before that
AI has been around for a while. But all of a sudden there is major focus on it, and the development on AI systems and their applicability and deployment has accelerated dramatically.
For sure.
So the challenge for legislators then is, as you said, playing catch up, looking at what is happening and adapting existing laws, or coming up with new laws which are tailored to those specific developments. And the challenge is the pace. It has to happen quickly.
It's always like that. I mean, in Malta, back in 2018, we had the legislation on virtual financial assets, crypto, blockchain. was a very, for want of a better word,
intense,
yeah. And very attractive. Now it's sort of phased out, and now we're focusing on AI. And I'm sure, especially with developers, AI comes very much like, how are we going to make a game more attractive and more AI or augmented reality more attractive to the customers, whatever. But before jumping to AI, because we are discussing this very, very rapidly. You mentioned guidance by the regulator. Do you think we have enough guidance by the regulator in Malta and other
Okay, so maybe just as a bit of a disclaimer, this is not, I'm a bit outside of my area here.
Yeah.
But as I said, we work very closely with compliance and regulatory teams, so I can see what's going on. I think in Malta, we do have quite a bit of guidance. I think probably where guidance is lacking is in some of the jurisdictions which regulated a bit more recently. Obviously, because it would be a newer framework, which would be, they're just implementing it, so it's still being developed. Obviously, there are always going to be areas where operators and players within the industry can do it with more and better guidance. So I can think back, for example, when GDPR was introduced. Initially, there wasn't much guidance, neither from regulators, neither judicial guidance, because we didn't have decisions on GDPR and so on. So that, I think, is something which builds itself up over time. Once a legal instrument is implemented and is enforced, and then the guidance and judicial decisions and case law develop on top of that.
Okay. So since you mentioned GDPR, I'm going to ask you about privacy and data protection.
Yes.
So with the rise of online gaming, how are privacy and data protection laws affecting the gaming industry?
Okay, so I think GDPR had a very significant impact on the gaming industry. Obviously, we had privacy laws before GDPR, but maybe they were not as much in focus. Also, GDPR carried the threat of very high fines and serious consequences for operators, so that kind of threw it into focus. What did that mean? That meant that operators had to understand, had to acquire the knowledge regarding processing personal data. They had to reflect and consider exactly what they are doing with personal data, and obviously they had to create quite robust systems to make sure that they're doing it in a compliant way. And I think the most fundamental change with GDPR was that it required a change in mindset. So I think previously privacy may have been a bit of an afterthought, whereas GDPR really pushes for privacy by design. So while we're thinking about a new system, a new tool, a new product, whatever, at the planning stage, we're already thinking about privacy, we're already thinking about personal data, how we're going to be compliant and so on. I think that's the major impact.
Yes, of course, it made it very, very important. What I've noticed, though, is that sometimes players would use their rights as outlined in GDPR to obtain either the cash back and all that. It's a tactic as well, not only used with customers, with players, but it's something that I've seen also in employment disputes as well. Slightly unrelated topic, but so if there's a sort of constructive dismissal or unfair dismissal, they would use the GDPR, like how are you using my data, there's a breach, and then use that breach for their employment dispute. Have you ever experienced something like that, not from an employment point of view, from a player point of view, whereby they try and use their GDPR to get their money back? Okay,
so I can obviously comment generally.
Yes,
I can't
of course.
comment about specific cases which we've had internally.
Breach of confidentiality.
I think there is an element of data subjects potentially misusing GDPR, because obviously the intention behind GDPR was to protect data subjects, not to enable them to abuse of the rights they're given within GDPR against businesses and operators. So I think the solution to that would be, well, first of all, there are mechanisms within the GDPR itself which do cater for these situations. For example, there is a mechanism which enables businesses to withhold certain information if there is a concrete in a litigation context.
Yes, exactly.
Subject to certain criteria.
Yes, or for example, the right of erasure.
Exactly.
The right of erasure,
But,
which is unlimited.
Yeah. I also think it is for the courts then to give interpretations of GDPR and the way it applies to ensure that it is not misused, neither by data subjects and neither by businesses. I think that's where the solution lies.
And do you think that the judiciary, especially the Maltese judiciary, do you think they have the necessary expertise to make a judgment on a GDPR issue, for example?
I see. Okay.
Because from my experience, for example, my opinion is that judiciary in some areas, for example, AML, which is very important, and CFT, anti-money laundering, and counter-financing of terrorism, the judiciary do not have enough experience or expertise in that area, and more often than not, they would interpret the law incorrectly.
Yeah,
so
okay. I think this is quite a sensitive and controversial probably aspect.
That's why we're here, to create controversy.
System. I think the judiciary have a very difficult task. Why? Because there are now so many, specialized areas of law with so many different complexities, including, gaming, including tech-related laws, financial services laws, and so on.
Yes.
That what we have is a judiciary, which is obviously quite a small judiciary.
Yes.
Which needs to quickly sort of gain the level of expertise needed to take certain decisions. So I would sympathize a bit with the judiciary. I think we do have a very capable judiciary, maybe slightly under-resourced, but all in all, I think they are a very capable judiciary, and they do, in my view, a good job at keeping pace with fast developing legislation and very, very complex areas of the law which they are called upon to apply in a fair and just manner.
Yes.
Obviously, it does take time. So again, GDPR, for example, is the first few cases that we're seeing about GDPR reaching the Court of Appeal, for example.
Yes.
Gaming, if you went back a few years, you would find very little court judgments regarding or even involving gaming operators. But over time, as gaming has been and is now sort of a cornerstone of the Maltese economy, and there's so much activity in gaming, then the courts get more and more opportunity to hands down to analyze legal aspects, and there you start seeing probably the quality of judgments given actually increase over time.
Yes, and no, that's a very, very valid and very fair opinion that you made. I'm impressed. Well done.
Thank you.
So intellectual property is a major issue in gaming. What are the common IP challenges that gaming operators face nowadays?
Yes, so IP is very important for gaming companies. Obviously, gaming companies are tech companies, so IP is one of their most valuable assets. That is where the value lies.
Yes.
In terms of the legal aspects, obviously, there is protecting your brand, so making sure you have the necessary trademark registrations within the jurisdictions where you operate.
Exactly.
You have a heavy IP element in the contracts which the businesses enter into. The vast majority of contracts are software license agreements, which are actually IP agreements. So you want to make sure that your IP clauses in those contracts are as they should be. And then also obviously for any operator which has which does development work and which develop their own tech and their own products or perhaps their own games, if you're talking about B2B, then there is IP ownership, which is also a very critical IP element which you want to get right.
Of course.
So you want to make sure that your source code is that you own your source code, you have the right clauses in your employment contracts and so on.
Yeah.
And I think there is an element of IP also in emerging areas such as AI, which you mentioned. So I think over there there are still some question marks, which I probably don't have time to get into detail, but
for the next episode, maybe.
Perhaps an episode in itself.
Yes, exactly. Mike, I'd like to thank you for joining us. This has been very insightful. I think I understood how vast the topic is and how much more there is to discuss. By way of conclusion, what advice would you give to new gaming operators to navigate the complex legal landscape successfully?
Okay, so if we're talking about new gaming operators, so essentially the startups, the ones that are sort of joining joining the game.
Pun intended.
Yeah, what I would say is get your legal and compliance right at the outset.
Yes.
Often, startups especially will be more focused on, more exciting aspects like, growth forecasts, marketing plans, and so on. And maybe the legal and compliance goes onto the back burner or is forgotten. But it is actually more costly if you get it wrong and then have to sort things out, rather than if at the outset you invest in a good legal team, a good experienced compliance team, you start building a network of external lawyers and get your compliance and legal and your contracts right at the outset, and avoid having to incur the cost and the frustration of having to fix it probably at the last minute.
Yes, totally agree.
I think from a legal and compliance perspective that would be my advice.
Totally agree. Thank you very much, Michael. And thank you for our listeners who joined us in.
Thank you again for the invite. Pleasure to be here.